Greg F. Tandilian, independent consultant. First, thank you for your talk. I'm a little confused, though, about getting from point A to point B. And by point A, I mean in the protocols, it calls for to implement a dialogue of historical dimension. Now, it's clear Turkey wants to use that subcommission to debate the Armenian genocide, whether it was a fact or not. But you're talking about arbitration. So in arbitration, a country would then have to say they agree to arbitration. So I'm just a little confused how we're going to get from one position to the other position. Thank you.
Catherine, do you want
Okay, let me start in reverse, actually. Let me first answer your question. What you have to understand is that in the subcommissions, so we have a major commission. I'm talking about the protocols now. You have in the subcommissions, you have two subcommissions. You have one on legal issues, okay, and one this historical commission. Now, the historical commission is drafted in a way that is very unclear. One, very unclear. Second, that some people say it should be a pure historical commission and no legal matters, but some others are saying, well, there will be some legal matters that are actually dealt with in that subcommission and so on and so forth. I am speaking about a legal and not a historical, a legal mechanism. I'm not speaking about a historical mechanism. And if I were the person to, but of course I'm not, to put into concrete action the subcommission on the historical dimension, actually again, historical dimension of what? That's missing. I would not put lawyers in there. I would not put lawyers in there. Now, I don't know what the states are doing, and I don't know whether they will put lawyers there, but I don't think they belong there. But they belong to the subcommission on legal matters. And so my proposal goes to the subcommission on legal matters. That's where the point A, your point A is the wrong one. My point A is the subcommission on legal matters. Now, you may very well say, and this I agree would be a difficulty, that there will be overlapping issues. But remember what I've said. I've said that for me, I don't think we should accept the question of the legal characterization of the events in that subcommittee. And that's the only, and I'm very sad that our Turkish representative of the Turkish embassy here has not listened to me, because the way he has been portraying what I've said is the exact official position of the Turkish government. And you have not listened to me, sir, because I have been trying to do as much as I can to go outside this traditional view. And I wish I would meet with other people from your country, sir, where I have met in the civil society, but not at the legal government, not at your level of representation. And that's very sad for me. And that's the only thing that I wanted to tell you, because you didn't ask any questions, so I'm not going to answer any of that. So I think that's the difficulty we are having, is that we have official positions that are not going to change. And what my hope is that this is going to change. And that as long as we are going to have this kind of discourse, things are going to stay exactly the same.
I have a question, actually.
Well, later on, perhaps,
Just
if
one
Mr. Murphy is giving you the floor. I saw also lots of hands on that side. Now, on the specifics of the legal mechanisms, I'm not entirely sure I have the time, because it's quite complex. But let me answer in this way. You take a dispute, okay? And let's go mathematically from A to Z, from who are the parties, what kind of questions, disputes they have, how they are going to present those disputes, in which calendar, which languages, what kind of proof, how they are going to be presented to what I call the tribunal. But again, Sean Murphy has mentioned conciliation or mediation. I mean, we have to think in terms of an ad hoc mechanism that will cater to the specific needs of this particular dispute. And so you take every single aspect of it, and already we have some experience, already we have some answers, but again, the reason why I didn't want to go into the specifics, because it's not for me to say at this stage, we would prefer to do this or we would prefer to do that. We have experiences, so we will need to put on the table the experiences that we have gone through in different kind of disputes. I mean, we may talk about the dispute between Eritrea and Ethiopia. We may want to discuss about other kinds of disputes which have gone through some kind of arbitration or something like this. And again, we have experiences, but we also have to make it our own mechanism. So the experiences that have been we have had historically are only good as one possibility. They are not good for the, as a model. I'm not speaking of model. You didn't hear in my speech the word model. It's not what I'm talking about.
Thank you, Catherine. Let me just take the prerogative to respond as well to the three comments. One of the advantages of moderating is you get to do that, but we will have another round at least of questions. First, if we're trying to think of what are some examples out there of the kinds of things Professor Kessedjian is talking about, again, depending on what the issue is exactly that this alternative dispute process is trying to handle. For instance, if you wanted to have a clear demarcation of the boundary, then one possibility is something like that UN boundary commission that was set up to demarcate the Iraq-Kuwait border. It was thought useful to have a group go out and actually put down the markers. Ethiopia, Eritrea, also an example of a boundary commission set up first to delimit, then to demarcate. Not as successful an outcome. Although it's interesting now with the very sophisticated mapping capabilities, how you can electronically demarcate even if you're not actually putting the pillars on the ground. Whether that's a helpful thing in this context or not, I don't know, but that's the sort of example. There certainly have been investigative processes. The Dogger Bank incident comes to mind, where a famous arbitral process whereby simply a factual circumstance was looked at and passed upon by an international body without necessarily leading to any particular consequences. So I think there are examples out there. I suppose I would circle back, though, to Greg's point, I took to be, is this really feasible, right? I mean, and I was trying to say this myself in my remarks. We had the two protocols. The two countries clearly got together and tried to work past their issues and decided this was the best way to go. Is it really the case that introducing some other mechanisms is needed, is helpful, will be effective? Is it more likely to exacerbate problems? Is it even